from this area speak to us. And so John has over 40 years of experience and is what I would call a pioneer in the Canadian financial planning world. He he's done a whole lot of things that's actually, been involved in practice standards, in visionary concepts with advanced professionalism in the field. His role right now is at the Attorney General's public guardian and trustee as a senior financial planner. He's also got a prolific volunteer world that he's helped out. In 2020, he received the Institute of Advanced Financial Planners award for the volunteerism within that organization as a director and executive. But John's volunteered in so many other capacities, been a chair of education, secretary and treasurer, and actually is also a dragon boat person, which I was excited to see because my daughter is a competitive dragon boat person as well. So,
Oh, fun.
anyways, yeah, she's actually on one of the Canadian teams and going to Germany this summer for the
Oh,
international.
great. Yeah. I've been on a number of national teams, but I didn't start till I was in my 40s. But
Right.
I probably know the coach. It's a great way to meet a lot of good buddies. And if she's going to Germany, that's great. Yeah, I raced with them at the Worlds a few years back. But yeah, it's fun. It's
It's
a lot of
great.
fun.
So I'm going to step back and let John take the reins here.
Okay, I'm going to try. It's John Burns here, so I'm going to share my screen. Hopefully, it works. Um, there are th I depending on time, I likely will just go through the slides. There's lots of added documents, things of this nature, but I think Linda, you're able to share that with the people afterwards, right? In terms of the package. Yeah, we can do that. Okay,
Yeah,
let
I'll
me.
share everything after.
Okay, great. Thank you. Okay, so let's do this thing. Okay. Now, you can talk, but I've only got an hour for presentation. I think we got 90 minutes in total. Can
Yep.
everyone hear me? Put your thumbs up if it's okay. And can you see the first screen? Thumbs up, two thumbs up. Okay, great. What we're going to be talking about, as Linda was saying, I've been over about 40 years in the business, but the last 20 years have been with the public trustee, and that's an interesting story on its own. Um, so if anybody's in any province, we do have public trustees in each province. So let's see what I can start with. Hopefully the slides work. Let's see. Yeah. So I've been over 20 years in private planning. I was a wealth manager, portfolio manager. I've worked with the big trust companies, banks, insurance companies, wealth management funds. I used to be a stockbroker. Uh, I've spent the last 21 years with the Office of the Public Guardian Trustee. I am the senior financial planner. I've also worn the hat for a number of years as the chief investment officer for the Attorney General. But financial planning is in my blood, and I prefer to do that than the C-suite jobs where you're just stuck in meetings all day. So I have, all the regular designations. My CFP, I'm a TEP, I'm a chartered investment manager. I've got the chartered wealth manager. I was an FMA, fellow of the Canadian Securities Institute. My education is simple. I went through University of London Law School in finance through their master's program, financial services law, and my MBA is through the Edinburgh Business School. And so I do have my DNA is about 70% British. Yeah, so that's kind of where that comes from. Um, Generally, the PGT, and this is pretty well the same, I think, across Canada, is that in Ontario we operate under the Attorney General's office. Our division is called Victims and Vulnerable Persons Division. So we safeguard the legal, the professional, financial interests of incapable adults and individuals, minors, and estates when no one else is available. And that's very important, is that we are, and I'll show you a slide later on, we are not the first place, and we do not go out looking for the clients. It's the opposite. We prefer all the work to be done in amongst yourselves and your legal professionals, your accounting professionals, and the client you serve. Uh, our key service, we obviously in Ontario and most provinces, we act as a substitute decisions maker for these incapable adults and individuals. We deal with the financial. I do mostly through my arms, but we will have situations where we have to make personal care decisions at in the hospital or long-term care decisions. We manage the trust funds for the minors with litigants. Lots of times there's significant funds going through the courts, and so we have to step in there when the judges request that we help them. Um, we also deal in Ontario with quite a few perpetual care issues. We have hundreds of cemeteries under our Cemeteries Trustees Trust Act that we also manage their funds. Clients, many people in Canada still die without a will or an executor, so we step in there, which is again a fair bit of our practice. Charitable properties, if there's concerns about the way the charitable property is being managed, etc., allegations, things of this nature, well, we can step in there. So we really are the protector for almost anything and everything that happens in our province. And we're governed by the Public Guardian Trustees Act, 1992. And we also can act as I mentioned, litigation guardian or legal representative if we're in a court proceedings. Now, this is Linda thought this was, and I thought it was a great idea too, just to give you a heads up that we are provincially regulated, and each province in Canada has PGT as well as the territories. But by far, because of the volume and the size of the province of Ontario with 15 million, we're th- we're the largest. We managed we just 2.9 billion. Actually, it's over 3 million when we have pulled in other assets, but. And then we have British Columbia, this is about a billion. The same with Alberta and Quebec, Manitoba. So just the pecking orders there, and it's indicative of the size of the population. And for the most part, we tend to manage similar mandates. There's a little bit of difference in each province, and we do have a national association of public guardians where we do share. It's similar how all the individual securities commissions would share and try to handle things in a global way, but at the national level. But as you can see, most of our the assets are, are largest in this province. So, not that we are always correct. In fact, it's not the case, but they say, okay, if you're having to deal with this with the large, we'll test things in Ontario and hopefully then share. And that's a wonderful scenario. So if you're working in another province, other than Quebec, which is not common law, it's civil law. But we all share similar traits, similar issues. And as the federal government is getting more involved with issues with disabilities, uh, we have that commonality. Now, what I wanted to do and is just give you a heads up. We just did the annual report, and we'll share that with you. It's public domain material, but just give you insight in terms of the depth and breadth of what we have here. So, if you're dealing with a public trustee, you say, who are we and what do we do? Well, uh, we manage, just about 13,500. I think it's almost 14,000 clients now, all ages, um, over 5,000, 5,500 of them we call complex, i.e. they have at least 50,000 in assets. They have multiple investments. They have external investments. They own properties worldwide. Because Canada is a country of immigrants, so you can imagine what that entails. I mentioned litigation. We have at least 500 ongoing guardianship and legal representative litigation cases where a person is found to lack capacity, and we have to step in and represent them in court. As I mentioned, we have $2.9 billion assets under management, and that's the arm and the hat that I tend to wear with my team here, where we have to manage their funds, traditional investments. But if people are familiar with the Substitute Decisions Act, it's basically national. We have to, in Canada, and specifically, say, in Ontario, act as a prudent investor, which means that we have to try to get the returns and we have to deal with not just a short list of investment, but anything that's capable of helping our clients because we're pure fiduciaries. We need to be very clear about what and where we can find those funds. So for Ontario, we deal with RIFs and LIFs and LIRAs, TFSAs, segregated funds, RDSPs, individual securities, oh, even holding companies. I've managed significant assets for individual corporations and people who lose their capacity and their circumstances are such that they end up under our care. There's an area if they do become our clients, we will be in the position of saying, uh, would you, if we can find someone who's within that list of, I'll show you, of who can take over for us, we do recommend that they try to uh, present an application to replace. Um, the other key thing is we get involved with, as I said, it's not really on the asset side, but Substitute Decisions Act for medical treatment for long-term care, significant. We have many long-term care senior citizens who are living in these homes and nursing homes, etc. And if they do not have a decision maker, we can be brought in for that purpose. Not me personally. Obviously, we have many departments within the public trustee. We've managed about 1,700 plus estates. So that's about a couple hundred million in cash and in properties and millions in investments. And another very essential part is the account of Superior Court of Justice and the children's lawyer in Ontario, um, where we deal with mostly as a trustee. We don't really handle the day-to-day lifestyle needs of the client, but many children and adults. The funds will drop into our account, and then we have to manage them prudently, and so it's a ongoing operation, and it keeps us out of trouble, and it's good to know. So just give you a heads up. As I mentioned, the roughly say, let's just round it off, $3 billion we have in investment. We do manage them within a number of various core investments as well as our external investments. So we're in this kind of good position where we're able to get very high level economies of scale because the magnitude of what we have under management. So we're able to give a good price point, and we're legislated under the Trustees Act in terms of what we can charge for our clients, which is very good. The most we can charge for all the service we have to render is 0.6% on assets under management and say 3% on transactions that if the client needs to transact funds. So our underlying funds here, for example, the fixed income fund, we've all done against the benchmarks. We're normally in the green. We have a very serious investment advisory committee that is made up of blue chip professionals and heads of major corporations, major pension funds that sit on a board, and they meet on a quarterly basis to review our mandate of how we're investing. So everything from very short term daily interest accounts to a long-term growth portfolios, we can handle that. So we have dedicated individual accounts as well as external funds, but a large part is in-house. But the key issues, this is a very simple table that we tend to, if a client does come under our care, for example, if you had a client and the PGT became involved in some capacity, or someone has reached out to you, if we're going to invest their funds and they are with us, we've basically developed very high level and very detailed investment policy statements as well as know your client documents that are uniquely different than you would see with, say, an investment house. Follows the same way because I come from that world, but the other issues we add into is the client's age, what their health is like. We have to do very significant health assessments for the client, and what their income is like. Can they secure and not secure a sustainable income, or do we have to use the funds that they have available to pay for it on a regular basis or a periodic basis, or they don't have it? And with doing that, we create different portfolios, and then it's simple as you would likely do in the private sector. We then have portfolios that are made up very similar to what happens in the real world, outside in the private sector. We have from a very secure, which is 100% daily interest account, which I think as of June 1st pays 3.6%, all the way through to a growth portfolio with, we can have a reasonably high equity weighting for those clients that may come in at 18, 19, they're young and they have a long-term time horizon and they're in good health and they have other assets, things of this nature. We may find all along that pattern that if they come within our portfolio, they are under our care, even if they're outside. So we will review how they currently are being managed, and we may adjust. And if you are working with us, you may find that what we're trying to do for our client may not be too out of whack with what you were, as a financial planner, had been dealing with or expecting to. So,
John,
biggest, sorry.
Al Dick had a question. Did
Oh,
you want?
sure. I missed that. Okay. I should be ending. Okay. Al, I'm here.
Yeah, thank you very much. You are addressing a question that I've had for a long time
Oh, good. I'm
um,
glad.
about KYC for dependent people.
Right.
When I was in practice, now this is on a individual corporate level.
Hmm.
Um, I never understood, like, if someone died,
Yes.
let's say the second person, as a couple.
Yes.
If she passed away, and let's say she was in a growth portfolio,
Yes.
and then and her beneficiary slash will says, "I leave everything to my kids." Uh, where is the company's responsibility to perhaps shift things from a growth portfolio to a secure portfolio while the will is being probated? Does that ever enter a conversation?
Well, okay, I can tell you quite clearly that people every single day, especially when I was wearing the chief investment officer's hat, people are dying every day in our office. And if the client may be in, like you say, maybe if they're an elderly person and they've been with us for a while, they may not be in a growth portfolio. But let's say if they were in a growth portfolio, the person dies, they're no longer have a family, like a spouse may not be around, or their estate is finally going to be distributed via the will, for example. Um, we generally, because we have a deemed disposition on death, we will almost, if we have access to the fund, and this is why, uh, just to give you a heads up, within the public trustee in Ontario, one of the things that I was involved with was being able to unitize our funds and create our own internal funds so that we would be able to quickly make decisions and implement those decisions. So if someone died on Monday, we found out they were dead, had deceased in nursing home, if they were in nursing home, contacts us, we'll say, oh, the client died on Monday. They were in this portfolio. Um, we would have an assessed, hopefully, where the client's assets are to go. Maybe if they're named beneficiaries, that's one thing. If it's a registered plan or a TFSA, if not, we will this most for most estates we try to move the assets to secure portfolios. That's kind of because we have the decision-making capacity within the public trustee to do that. If you have an estate with a named, estate administrator or, executor, then they are supposed to do everything they can to preserve the value of that estate as well, right? So a death is almost always the simplest issue. It's when the person loses their capacity, where you have family members don't they're knowledgeable about what the assets are, and they don't want certain things to be changed or modified. Whereas the needs for the person, say, under our care, their needs are, you know, somewhat different than what their family would be, especially if they were using the same investment advisor, or that a lot of times the kids or the children may have been trusted partners in that relationship, so they were helping with the investment advice. So, but generally, we go try to go to safe harbor. That's a simple thing. Is the client's assets at risk of loss, and will there be a concern that what ends up being distributed eventually will be less than what the client passed on would be passing on? If that's the case, then is there a risk and the attorney general and the public trustee isn't kind of a body that can hide. So we have a we do get all the time individuals who will litigate against us, say, oh, listen, we could have done better, or you missed money here, or you lost money there, and so then we have our own assurance funds where we are responsible for making good. So we don't want to go in that position. That's one of the reasons our unit was created, so that we do what's right. So uh, I don't know if that answers your question, but the bottom line is that if you're dealing with an estate and the estate is to be distributed to the children, and for example, hopefully one of those beneficiaries is also involved with the decision making. Would that be the case in the scenario you're talking about?
That's a good
No?
question. That's a good
Yeah.
question because there's that time in when it's in no man's land.
Yeah.
Well, paperwork is being processed. So yeah. Anyway, I
Right.
just was
So
just
the bottom line is that most executors should take the step of moving the funds and dealing with obviously tax consequences as well. Most people on death, except rolling it over to minors or our surviving spouse, will have their tax date pretty clearly defined, and so finding the assets, the last thing you want to do is have an asset that's worth $2 million at point of death. And by the time you turn around selling it, it's worth 500,000. But the Revenue Canada technically may not care about that. And we've gone through those type of cases as well, where the deemed death proceeds are that date is a different valuation. And
thank you
then,
very much.
okay, all right. So
Yeah,
keep on going. Yes, but that's a good question. And like you say, the whole point of common law, as you know, is that there's no single defined answer. It's all done through what precedents and who had the better argument when you go to court, which is great. So so you always want to read, and that's what I love about this. I'm on the finance side, but when you're dealing with who are the dissenting, who are the arguments that didn't win, so okay. Those are good points. Maybe not specific to that one case, but let's put that in the back, and maybe we'll have to bring that forth for the next time we have to deal with this. So, but if and your position though, if you do have clients, and obviously you do have clients, just make sure that if you start feeling that something is a little less clear in terms of when you're sitting down to them with your annual review, or when they're calling up asking for sort of big withdrawals, or you can just get it. When certain times or circumstances are such that, or someone else is trying to take on authority or a new power attorney, and you're not quite like red flags will go up. I mean, I'm not going to go into it here, but there is always concern. Uh, the persons could, and there unfortunately may not want to do it, but the capacity assessments are something which we recommend. In the best case scenarios, no different than making sure that if you sprained your ankle or whatever, so you may have that looked at. The capacity assessment is something that is low cost, a couple $100, but it does give you assurances. And unfortunately, if that falls out the way, then the court, or you get appointed under the Substitute Decisions Act, which means that the, the the wheels have fallen off, and the client's capacity is deemed to be incapable, and we may not be able to say what they may not be capable, or they may be deemed capable by the courts not being able to manage their own personal affairs. But if you are concerned about someone, you can contact us. You wouldn't contact me directly, but we do have, if within Ontario, and each province likely has the same. You can contact a person, if our office, if you deem someone may be found incapable, and you may not be may be the trusted advisor, financial advisor, something of that nature. That's fine. Like people, it's okay to take that issue. And the OPGT, we could investigate. If they're found incapable, and there may have either personal or financial harm is going to come. And we don't have a proper uh, power attorney or someone doesn't come forth, that can happen. But then we do have investigators, full-time investigators, and they're out there all the time just trying to identify the individual and working with whatever judge has made an assessment. And and the client could be found incapable either on a temporary basis or a permanent basis, and if that happens, then there's a whole, the wheels get pulled into motion, and before you know it, the public trustees involved. It's and it's very clear, like we're either fully involved, we take over full authority, especially for adults, or we're not. It's like it's almost under Substitute Decisions Act. The courts hate a vacuum, so they say, "Are you involved? Are you responsible? If we're responsible, then we got to act on it." So it's important that you uh, 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 take action before that happens. So obviously, everybody and every one of your clients, I do hope that they all have power attorneys. In Ontario, we have two types, as you probably are familiar. You have the power attorney that most people are happy to deal with, which is the for personal care for the parent or the spouse or the child. Yeah, I definitely, the person I care for, I love, is going through some hard times. They've had an accident, or their dementia is adding up, or they have also all these conditions, uh, and you're willing to. And then the second one is property, and that's where we find people get a little bit more concerned, because managing someone else's financial affairs is it's not something most people want to take on, which is where we kind of come into the pace. And to a certain degree, yourselves as financial advisors and planners will be asked to step in. And so, you get that, you get the regular capacity, and just let the families know if something is happening, especially if they're not, if they haven't taken the steps. And we know procrastination is the biggest problem. Whoops. Okay. 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 Okay, so, but here's just to give you a quick heads up. As I said, we have a lot, billions of dollars under management. We have thousands upon thousands of clients, but we don't get there by head, door knocking or doing any type of. I did enough of that over 20 years. So there's a whole list. Either the court appoints a guardian, okay, or we find that there's a person with a power attorney for personal care, and and it's deemed an acceptable document, which is great. Or there's a consent and capacity board in Ontario. You can have a representative gets appointed, or obviously a spouse of a partner, the child. This is sometimes you might have someone and going in the hospital, like a kid or a brother or a sister or parent or dog. So someone has to make a decision, because the person not capable of making that decision to do like put a cast on or fix a broken leg or things of this nature. It can be as modest as that. But we try to go through, the courts and the hospitals, whatever, try to go through that whole list until finally, okay, we run out of options. The PGT now has been pulled, is now involved. And so when that happens, okay, that's where we take on guardianship. So if you do have the issue where your client, and this happens all the time, I've been in the business here long, and I've been like Linda knows, I've been with the Institute of Advanced Financial Planners, and I'm the founder of the Financial Planning Association of Candidates. So, around the block a fair bit and get a lot of conversations with other financial professionals. If you're going to work with us, these are just, I think, hopefully, I'm not speaking uh, out of school on this, but talk to us if because the first thing that will happen is that we'll have an investigator, if the client comes under our care, have full access to all the personal records. They'll be able to go into the home of the client. They'll be able to go to their banks. They'll actually be able to open up safety deposit boxes. They'll be able to do the more intrusive actions than the police or CSIS or anybody else really has a right to do. The public trustee literally wears the hat of the client, and we're in that capacity. And so we get copies of the client's wills. We get if there's our power attorneys, we can dig those out. We can identify who those interested parties are who should be taking on authority. we'll do that and we'll try to identify it. If the client's investments are, for example, with yourselves, then we'll find the most recent document. Letters will be sent out to the institution, and sometimes uh, I'm not involved in that end, but sometimes the letter will go to the wholesale firm, and then they'll have to find out, well, go through who is the licensed investment advisor, and so it can be somewhat a curious route before someone who's in a decision making position on the investment side gets back to us. But maintain professionalism. We're there to get a full documented assessment of where this client currently sits, you know, and then we can, from our end, determine, for example, are they, as we say, is it a complex case with over $50,000 investments? If that's the scenario, then our team of financial planners, CFPs, CFAs, we're all mostly we have accountants, etc. We might get involved on the investment side. So if you can provide all that information, the account statements, investment portfolios, it's going to help us. And the more we can communicate how we see, because we are now fully responsible for managing the client's affairs, and we have to, as I showed you earlier, we will hopefully identify the type of portfolios that we think is deemed pertinent for this client, because the client may be invested. Like you mentioned, now that the client could be invested in a growth portfolio, but their life expectancy and has taken a downturn, and their needs for finding funds for long-term care. All that may change. Therefore, the growth portfolio is no longer appropriate. Might have been 6 months ago, might have been 2 years ago for the last time. But at the current state, we will need to take prudent actions. And we do more tax returns, I think, than almost anyone else in Canada. You imagine. So whenever we're trying to make a prudent decision, we do want to do what's best for the client in terms of tax planning. So we don't want to, but we take risk and the tax issues as well as the client's needs all into consideration when we're making those decisions. Obviously, it's very important that we try to deal with things in encrypted manners when we can, so that there's we don't want unnecessary. We don't want anyone who's not directly involved with this act to get hold of any pertinent personal information. Um, we will be very clear about what we're and how we're going to manage the money. And it's always about preserving and keeping the client's assets. They may have set up things for the next generation, and we'll try to believe that that's important, but we take precedent over helping the client themselves. We tend to deal with relatively low risk, although we can. We don't deal with alternative investments. We don't deal with cryptocurrency things. We don't deal with individual securities. So people may hold a portfolio of individual securities. So we will assess if we're going to sell those off. There's every client is unique, but we'll deal with that. Um, I'm inside. I work specifically for the crowd for the public trustee. I don't have any clients other than working with the public trustee. So 100% authority, responsibility is working with them. I don't keep any other business going, things of this nature. So whenever decisions are being made, it's to deal what's in the best client's interest and what is within the policy and the law under the Trustees Act. But at the end of the day, if we find that this client is not here for the short haul, but is going to be long term, it's highly likely that in order to find economies of scale and have access to the client's funds and deal with it accordingly, if you are used to managing the client's money, I'm not saying it's 100%, but you may find that the funds may be moved over. Now, obviously, we have clients, they'll come in with us, the large estates, something falls through the cracks, and they're part of a large family office. They have discretionary investments. The portfolio, there's a really good investment portfolio manager. They're on top of it. we'll do what we can. There's the funds are commingled in with other family members. All these situations come up, and so we're the decision maker for the client, and we can make the decision that the assets and the funds can still retain themselves externally, especially if they have an interest in a private company. Many individuals come in, they have holding companies holding real estate in North America, internationally. They have equity interests in companies. I've had to deal with a major international company, $100 million companies uh, with offices all over the world, and it's with 300-400 different lines of products, things of this nature, and it happens because private enterprises, even when they're set up, can circumstances come up, and we have to deal with it. So. It's important that if you're going to have anything to deal with us, we're not there not to take over. We've been put in the position where we by the courts and by the law we have to take over, and so because of this unique group today, the kid and I spent time working and talking to all my fellow. We have a I'm here, a handful of financial planners, but I'm surrounded by lawyers. Right? It's great. We're the attorney general, and so you want a legal advice. I just knock on the door, and that's it. So when Linda asked me to talk, I said, okay. I'm going to ask head of our litigation and other in family law, what exactly does happen if either uh, uh, the client's going through a divorce separation and they've become incapable, or the client comes to us and because of their incapacity, it's not um, they're not able to continue on. And so the short answer is we are acting in the client's best interest. If there is a separation or divorce going on, we are definitely going to be having to hire the same way as the client would an external lawyer to deal with this through the courts and the external and we'll take direction the from that counsel as to what is we should do, and then we'll scrum with this external lawyer and come up with what what is the course of action, and it's an important element. And if we may be managing the funds for a couple and one person's lost their capacity, and then the separation starts, and you really someone has to contact us and let tell us, oh my God, the client's going through a divorce or separation. The earlier the better. Um, it's very possible that we will work directly with the external financial advisor to help them, so we get a better idea as to what the quanta of the value of the estate is and what can and can't be divided, and where we stand, and this so nothing really changes there. Now, uh, one thing though, outside of an actual separation divorce because marital issues, um, we do have a wonderful thing in Canada, called the involuntary separation, which happens if someone does have to go, not because they come with the public trustee, but a lot of times that happens, but they lose they have to go into a nursing home, and so the couple is separated. So one person is staying at home, the other member is going into the nursing home or care facilities. We have a wonderful thing called with the federal government where the person can be deemed to be involuntary separated. And the benefit of this is that it allows you to split the income and the assets that's best suited to minimize the income for the person in that home. And that enables, in Ontario, we have many people cannot afford the high cost of private care, so they may qualify under involuntary separation. Their income may be low enough to meet the standards to get subsidized long-term care facilities. They may be able to maximize their guaranteed income supplement. They may be able to keep and stay inside a rent guaranteed income facility that if they're still able to manage from. There's a trillion drug program that gives you a good deal. Obviously, we now have in Ontario and Canada the seniors dental program, and I've helped individuals even family friends get on that, where they're getting crowns and dentures and cleaning. Everything is free now, so it's an amazing thing. And they can do their tax filing. We can still do pension splitting. They can still do medical expense reporting, but there's no change in the medical status. It's just strictly from a tax filing. I'm not going to go into much detail here just because of timing, but it's something that I think everyone, if they're able to help in this capacity, take advantage of. That's it. Okay. But what is important, that if the client is with us, for example, and they're with us, they deemed to be incapable. There's no ifs, ands, or buts. They're been deemed incapable. Um, that can cause a sticky wicket, because they could, in fact, what could have been a clean separation of assets. Now, the court may deem that the disabled person is still going to be dependent on the spouse who's wanting to separate. Um, so I don't know if anyone has gone through this. One thing that we've done a fair bit, and I get involved with, are dependent relief claims, and that's pretty clear. You end up with a scenario where um, the person who's now disabled has high costs to maintain, and what was originally hopefully a simple cut and dry of two capable people deciding to go their separate ways. We're going to divide the assets. People have their means of support, means of income, things of this nature. That falls off the table. All of a sudden, one person, because of maybe a motor vehicle accident or a severe illness or something of that nature, is now incapacitated. Guess what? This person who they had hoped to separate now is on the hook to financially support this person, and it could be for the rest of their natural life. We've had that happen. Uh, not just to the spouse, but it could be the former spouse. It could be a grandchild or parent. I've been involved where and we became CAT application. We became the estate trustee, and a client of ours is public trust is under the public trustee. They're fully incapable. They might have always been incapable. They might have had a severe illness or disability from birth. Guess what? They're they may not even be added or named in the will, because whoever set up the will said this one child doesn't have the capacity, so we can't distribute the estate to that person. They may not have taken hindsight and said, oh, we should have done a Henson trust, thing of this nature. Well, guess if a dependent relief claim goes through the courts and is successful, the pool of those assets that could have been divided amongst all the kids, both capable and incapable, it goes out the window. Basically, what will happen is that we have to do a care report for how long will this person, our client, need support, and what type of resources are going to be important. So that's it. That can completely throw whatever planning you had out the window. So it's important. Now there's a deadline. You're supposed to at least make it known within 6 months from the certificate of appointment to make a claim. So that's it. But that's a key thing. The other thing, and I know we're trying to move things through, what happens, and this happens, I kind of wore the hat here when there's an issue. It's called catastrophic settlements. We will all have clients who unfortunately get hit by a truck and their lives change forever. They don't die; they're totally incapacitated, and so their goes to court. And in Ontario, we have rules of civil procedure. It's Rule 7085, and it's a very straight up. It's black and white. You can look it up yourself. It says, okay, if there's uh, a judge is required to propose a settlement before it becomes binding on the part of anybody with a disability. It's very important. If a person has a disability, all of a sudden they feel that the balance between the two parties is now skewed to those without the disability. So a judge has to be involved, and this is where our little team gets involved. And I kind of ran this for, geez, almost 20 years. The judge requested PGT to do a detailed objective review of whatever that settlement is. And it could be a catastrophic injury settlement. It could be a settlement due to a malpractice suit. It could be a settlement because of a bankruptcy proceedings, and just trying to find who is going to be able, and what can we distribute, things of this nature. The client doesn't even have to be under our care. This is up to the court, and the judge will say, we'll get a handle. I could close my seminar right now, and I could get an email from some lawyers say, "Oh my God, the judge wants us to review this," and he says we don't need to tell them until close of day tomorrow, right? So to go with it, and so but what I will say that these settlement costs are not cheap. You know, if someone has a severe settlement to deal with a lifetime injury, it's going to cost potentially in the millions because we know that even though interest rates have gone up a little bit, they're still not anywhere near they were 20 years ago. So, but here's where the rubber hits the road. In 2016, if you're driving in Ontario, you had to, up until 2016, you had to have a minimum of $2 million of liability coverage. To save some money, the courts and the courts, the province, working with the insurance company, said you can reduce that to just $1 million, and you might save a few dollars on your premium. And so people are walking around or driving around with this $1 million coverage, when if in fact they did get in an accident, the claim likely will be in the millions of dollars. So if that's you or it's your clients, just have them review their insurance, make sure that they added the extra rider for another million or 2 million, which is going to be pennies in the dollar. Like could be under $20 to add that because they're not going to get into the second million until they first pay off the first million. So it's like having $1 million deductible for the next million. But we just see that coming up, and now the cases are coming in, and we're seeing that yeah, somebody has missed the ball and they didn't increase their coverage. So there's also we have litigation, which is statutory benefits under the standard insurance contract. But then there's also the tort settlements. And so we're talking years and years of this happening. And if someone is needing funds, we usually get a future care report from an external body, and they usually do the platinum plan, the Ritz type plan, the highest cost possible, so that the client could end up with a sizable amount. Most of these court cases, as you know, we probably see the ads. They're normally on contingency basis. So say the lawyer says, you don't get paid, I don't get paid. Well, that's exactly what happens. So they want to get the highest settlement, which the client needs, and then they'll be paid according to that percentages of what the value is. But what can work with you, and it has come up a number of times where someone has said, "Oh my gosh, I have to get involved with the client. They're going through a court settlement. Either they're the party that hit somebody or they've been hit, something of that nature." And I said, "Well, that's good. I can give you some clear advice that they're going to what's going to happen. If in Ontario it's deemed a catastrophic injury, that means the full value of what's under the Statutory Benefits Act under the policy comes into play. If it's not, doesn't reach a certain threshold, they won't go to court because there's a huge deductible. So I think it's over $100,000 now just to get into it. So if it's catastrophic, the lifetime, it's usually, and by lifetime normally has to deal with, unfortunately, a brain injury or incapacity for the person to ever work again. Um, then you, as a financial planner, could do a great job working with whoever your client, and if the legal is going to get involved. So I can send you stuff, but it's a very clear issue. You're just doing a planning as if the client is 32 years old. Now they've retired for life. Now they require $150,000 a year to live off. Okay, what are you going to do about that? And their life expectancy goes from normal 82 years, then down to 27, for 27 years, or they're going to, the assessments shows that the client's age has deteriorated dramatically because of the injury, things of this nature. So you as a financial planner could do a lot to help with that capacity. And the key issue is that if you get the settlement, it's similar to a lottery. It is paid out tax free. If you structure it with an insurance contract with an annuity, that can happen. Then give the client tax free income. But as you know, there's other needs for the client. They want to also make sure you don't lose their disability coverage if they have a group plan, or if they have government assisted programs like ODSP, for example. So if you're getting involved with this, especially if the client's of a younger age, there's lots of planning opportunities behind annuities, creating a diversified portfolio, maximizing the client's RDSP, setting up a proper trust, buying personal assets, fixing up the home to deal with the ramps and all these other benefits and discounts. There's a lot of cool things that you can do. It's to try to make the client whole, and so you can be very much the trusted advisor in this light. So get the client the DTC as soon as you can. It's very simple. Like don't miss out on doing that, because the federal government's getting deeply involved with benefits like the Canadian Disability Benefit and the Registered Disability Savings Plan, as well as all the other wonderful ways you need the DTC in order to get deductions, a variety of various deductions for care. Now, again, we just flew by that. I'm more than happy to answer any questions in our brief discussion afterwards. But where I also think you as advisors can really help, as I showed you earlier, we go through hundreds, if not thousands, of clients who they fell into our care because in law you realize the trust abhors a vacuum. Let's see how much time do I have. I've got a few minutes left, right? Trust abhors a vacuum. So if we get involved, the first thing we're going to try to find is there someone out there, a family member, able and capable of taking care? And like I had mentioned before, most clients will be more than happy to care for their aging mother or their partner or their child. But the financial side, they're a little more concerned. So if they are willing to take an application to replace, and we make that very clear to someone who is a family member, please consider making an application to replace. It's a simple eight-page report, and you as a CFP could be instrumental in helping them complete this page report, because it's going to go into where is the money's going to come from for to care for this person. What are the expenses for how long this person is going to be around in terms of care costs in the facility that they're at, the assisted devices, the medical, rehabilitation expenses, things of this nature. How are they going to generate those funds from disability insurance, from tapping their registered plans, from their portfolio, from and trying to get their CPP disability going. Maybe they can qualify for Ontario disability support payments, or in your own province, the care. You This all gets put together in a report, at least in Ontario, an 8-page report and you want to do this fairly quickly. You don't want it to be dragged out. If we get this 8-page report and a subsequent financial planning document done, hopefully by a CFP or a divorce specialist, that is added to our document. Then if it comes across my desk or a planner's desk, or it may not even need to meet our from the assessment people are doing the application, the potential for that management plan to being approved is fantastic. It raises up. There's also one of the key issues with management plans. Sometimes we have to bond, not we, but the person that's coming in has to bond the value of the estate, so that there's this is bonding, right? You have to go and find a third party bond, and you're responsible for it. So if it's a $2 million estate, the family member has to, if they are required to get that $2 million bond to make the estate whole if they decide to do something not kosher. All right, so that's very important. But a lot of times they, depending on the closeness of the partner, and that this gap between care and having the power of attorney properly set up, things of this nature, is what it was. The public trustee, can say we accept the management plan. It's all in good interest. The integrity of the applicant is sound. We don't need to pay for this bonding through the estate assets, things that are the value of the estate. So bonds can be, and I'm not saying it's always going to be the case. It's outside of my wheelhouse, but that's important. But if you're doing a management plan, or if the client or somebody says I want to get my authority back, the management plan is going to be have to be prepared, and you as a CFP, I would say, would be first and foremost a high priority to make that happen. Now, obviously, there's so many different programs that we get involved with, and you may or may not know. And again, I'm here to help, and Linda can give you my details, and I can within reason go there. But for example, we got the CPP disability for individuals and children. We get the disability tax credit is important. The disability tax credits for the RDSP, the Canada Disability Benefit, the Canada's Workers Benefit, the applying for involuntary separation that can help on a lot on the federal level, the provincial level. Obviously, we have ODSP, which is $1,300 a month. You can have 440. A client can have 40,000 in cash or in investments, not sitting in anything registered. They can have up to 100,000 in terms of an inheritance. And one thing that I was able to get through when in my earlier life was get the ODSP to accept up to 100,000 into cash value of a life insurance policy or even a segregated fund. Obviously, we have the $200,000 RDSP contribution, no ceiling on how long or how big it can grow to. We want to get people on the Trillium Drug Plan, assisted device programs, get them hooked up with gains to get extra money there, or PACE, or get them rent gear to income housing. So all of a sudden, this may not be part of your practice, but if you are have find that your client is getting involved with the PGT, then they are part of your practice. So the more you are able to, you have the heads up as you're finding out today, the better you'll be able to be a trusted advisor for them. And obviously, wheel trans, Meals and Wheels, all that stuff. Other things, lots of even my dad, who's now gone. He received a pension later in life, like when he was like in 70, 75, from Veteran Affairs, because he was at Normandy Beach and he got blown up there, and they came back and said, "Oh, okay, you qualify that." So it's his he was getting his snow shoveling done, and he got himself his electric chair to rise up and down, things of this nature. So there's lots of programs, and I like digging into what's available, and it is something that I'm more than happy to share. So if you're going to have a client regain capacity, and this is the last thing, and then I'll open up the floor. The client may in fact be able to regain capacity. They might have had a stroke. They might have had a car accident. They might have some other condition that made them incapable of making decisions, financial decisions. So they come in with our care. Normally we don't change much in the first 6 months, because a lot of times people come in, we have to be there as a stopgap, but hopefully the client can exit and things are fine. But if they're with us for more than 6 months or so, uh, if and they regain their capacity, there might have been changes in terms of their assets are been invested, and where the funds are now. And because of the economies of scale, like if we bring $3 billion in and we save external management fees, say 2%, that's 60 million a year of savings for our client. And then but the same with an RDSP or internal funds, guess what? If that client regains capacity, then they have no longer us to look after their affairs. They're 100% responsible, as every other meaningful adult out there is, to care and do something. And if they're still involved with you, or you're involved with them, or they contact you, the PGT is more than happy to ensure that whoever that advisor is going to be able to get all the necessary documentation pre-signed, pre-filled, capable of being rolled out. So if the investments are with us in a registered plan, and you're licensed to manage those registered plans, and your new capable client comes in with the PGT closeout package, we've seen things happen within 24 hours. We get it. Everyone's happy at our end. Last thing we want to do is have cases sitting around for months or years because someone didn't act on it. So we can roll out the non-registered funds. A lot of the cash is just sitting in we don't have a bank account per se. We have our investment account. That money is simply paid out in a check to this client, who then has to turn around and invest it. So obviously, you hopefully are involved with that. If the client has an RDSP, likely which is a registered disability support payment. We have, I know, 4,000 of those in our accounts, about 150 million or so. It's very likely that if you have a client under 50 years old or over 50, within the age that they could get an RDSP. So they probably have this because it's a fabulous plan. Then you've got to set up a new RDSP plan, roll out, change the holder status from us, the PGT, to the client, especially if the client is capable. And this is a capable client. Not this management plan where you're going to be a lifetime managing someone else who's incapable. This is where the client is actually found capable and is able to work on it and do what they want. And that's very important because until they find the institution that's going to do this or a financial planner, the funds are sitting in limbo with us, and it's not. As you consider it's not the right place for those investments because we no longer have any authority to do anything for these clients. We cannot invest for these clients. We can't trade for these clients. We can't do anything because we're no longer have any authority other than the funds that are sitting in our bank account or investment account. So that's about the key thing. If you're the planner, you can be a very solid liaison between the client and the family and us. You can work with the office here. You work with what they call a client rep, who's looking after this client, and and we're assigned as financial planners to client reps. And so there could be this co-op. We don't deal face to face with the financial planners, but we will interface with the client rep and yourselves if that's the case. And the key issue is we want the client to be to continue to operate even if they're under our care with as much autonomy and we want to build their wealth, we want to maximize their income, and we want them to live a quality life as what as much as possible. And we're in there to assist the client as much as possible. And hopefully, what I've shown you this morning is just a snapshot of what we do. And hopefully, you've gotten a few tidbits of ideas that might you say, okay, something will come up. Like Alan said, something comes up, and you say, oh, maybe I should reach out to this contact person and get that. So, other than that, I think I've covered what I was going to do over the last hour, and I'll hand it back to I can stop the sharing and I'll hand it back to Linda, and Linda can manage the any if there's questions and answers. But I'm here, like I say, I know where you're coming from because I've been a private investment advisor and portfolio manager and planner many years before this. Okay, all right. So, Linda, so I'm just going to drop it back to you,
Yeah,
and I know Bettina wants to say. Hope that
yeah.
makes sense.
I'll let you answer Bettina's question.
Okay, Bettina. Yeah.
Thank you. Good morning
Good
from
morning.
BC. I have a
Fabulous.
question. I've been in touch with a public trustee on the island for bankruptcy and consumer proposals, and
Oh,
that
of
is
course. Yeah.
very, very common. I shouldn't say that, but it happens more often than we think through divorce, either some weirdly mediated support payments or whatever. So my question is, so the public trustee works out of an office at MNP.
Hmm.
And what I'm not clear about, what is the structure? There is all those um, there's the creditor protection office or something where I'm not sure is this a for profit or not for profit. Then there's all those people who promise you to get out of debt,
Right.
and
Yeah.
those sometimes charge more. It's insane what they
Yes, sir. Yeah.
charge.
Yeah.
And
Yeah.
where do I place those? And can a public trustee work out of an MNP office, which is clearly a profit firm,
Yeah.
accounting firm?
Yes.
So that is my question. Where do I find the right person to say, hey, call the public guardian and trustee? They can assist you through the process of bankruptcy or consumer proposal, whatever is more appropriate.
Again, I work specifically in Ontario, but I can tell you, in fact, I have to, after I finish off with our session today, I am going to working on a relatively significant bankruptcy situation as we speak. where a person, we, the public trustee, we have to act, we're separate for any of these entities that deal with who's a licensed bankruptcy trustee. They're a separate entity and they tend to be for profit. They will take a certain percentage, either a fixed fee or a percentage of assets that are being, and if they're, and so you're absolutely right. They'll either say, here's a proposal, consumer proposal, which has to be accepted by all these parties involved, or bankruptcy, and they should be hopefully clear in that light. In fact, today, so that's where we're in the position of having to make a decision. For example, about is which first of all we had to find out an external body, so we had to literally the same as this client would have looked at various options, all these various like these for-profit entities, as to who we would want to contract with in order to work with us to make that proposal, because the problem, not the I wouldn't call it a problem, the client's under our care for the public trustee, but we then have to accept, and it's something that even our head of litigation here says, how do we again do that? We have to, give up our authority as trustee to enable the bankruptcy trustee to act and unfettered in our clients' affairs, to ensure that when they present to the bankruptcy court. And in Ontario, we have different tools. There's like a 9-month case or a 21-month case as to how long it happens, and there's all these extra rules. And you're absolutely right. When they start dealing with the fees and the costs, your head start to spin and say, well, the fees and costs are going to be taken out of the assets that the client has. They're not going to necessarily be added on top of that. So it's net neutral to our client. So, but at the same time, it's less than, say, the parties that the client owes funds to. So so if you're dealing with the public trustee, they should not have, they are separate and unique from any other party that you're dealing with under a bankruptcy. So that client, that public trustee in BC is going to be working for the client. They will have to do the same as if your client was capable, find the bankruptcy trustee. So, but they're not under the same umbrella. Okay. It's very important that you know that, and should be the same in BC. Again, I'd be surprised if I'm wrong, but in Ontario, completely separate institutions, and we're finding that out now. So it's the same, yeah. So it's does that answer your question? Like the bottom line is, you're not with the client who's with the public guardian. Is that the
Yeah,
problem that
yeah,
you're just
yeah. So I have there those weird firms who charge an arm and a leg, and I
right? But
know one
right.
who says no, and apparently the clients don't have to pay her. She is a public guardian and trustee, but working at the same time for MNP, where I'm like,
Huh.
okay, I don't know how this fits together, but
Well,
me,
yeah,
MNP
I
have
think
a
you get
contract.
clarity on that, because a public guardian, it's very defined under the Trustees Act and all these provinces and their rules, and they can act for the client, for the public, and
Okay.
that's it, right? But the fees and charges for your the bankruptcy trustee is a separate, they're separate. At least in Ontario it is. I'm surprised that the person is wearing both hats as a staff of the public trustee, because I mean, I'll double check on that, but I'd be surprised if that's the case. But
Yeah, I should do
yeah,
some research too. As
yeah.
I just took the opportunity and
No,
asked.
no, no, no. I'm glad you brought it up, because I'll bring it up with our head of litigation here, because we're dealing with the NAPTAG. We're just putting a paper together, what our agenda together for NAPTAG is. Oh, okay. Now that we're going down this path, and we know that the financial crisis is starting to ramp up, because there's a lot of homes that are going underwater. They figure the last 6 or 7 years, from what I gather, many homes that were purchased are going underwater, and there's a lot of potential. The bankruptcies are starting to increase, and that's a concern. And what we found is that you have a parent, and this is I don't think it's, I'm speaking out of, a parent holds their home in Toronto or say Victoria or Vancouver with a lot of money. They're losing their capacity. The kids are taking on the POA. They see opportunity to build their own estate. So they, as a power attorney, contract in to get new property and they refinance the principal residence of the mom. And then they'll take those funds, drop it into a new build, a new, and then before they know it, they're running three or four new or five properties. They now taken their mom's $1.5 million, $2 million home. They've got $1.5 million of debt against that have finance half a dozen new builds, and the wheels fall off. They're coming to close. They have to finance these new properties, and those properties current market value can't get the financing they have, and so they have to want to pull back. But they were acting as power as trust as POAs for the incapable mother who's sitting as 90 years old in a home with no idea what's happening, and so all of a sudden that's blowing up right now as we speak, and so automatically and the poor person who's living in, they're on the title, right? Because the power attorney, they set that contract. They can't change wills designations. They can't take beneficiary designations on a TFSA or an RSP or even change the will, but contracting for a new mortgage, things of this nature. Uh, yeah, so that's going to happen, and you'll find that it's. I think I've explained that people will take the equity from, and they'll think of ways to leverage, and by the time one passes, they'll have all these properties, and the tax liabilities are off the charts. Like that's so yes, and that's a problem, especially when you're dealing with properties. You can have a capital gain, and you can have a millions of dollars of debt owing at the same time. So these things are a ticking time bomb, and I'm concerned. And it's not and properties like if you're in BC, you're going to see that the same as we're seeing in Ontario. Yeah,
Oh, yeah. There's always tricky
it's very
setups.
tricky.
And
Yeah.
sometimes we see them in separation and divorce. And it's
Oh,
like,
absolutely. Oh, yeah. The certain circumstances. Yeah, because I can imagine that where parties have gotten into contracts and the principal residence becomes like they say, the giant ATM that they're going to use it for other purposes, and sometimes that's likely the reason why the separation divorces started, because someone's saying, "Oh, you've done this without my consent," and so it gets even worse if the person's under our care and they can't give consent to begin with, and decisions are made, and so then you have to go back and sometimes, and that's I didn't get into that, but in all provinces there's a way to review or cancel or reverse contracts if a person is deemed incapable now, and they can go back up to a year or sometimes further, and it again at least a year behind signing something. So and then trying to unbundle something of that nature, but. I'm not trying to be negative, but we see situations where most times the capacity for someone to regain or recover lost investments and assets when they've been taken advantage of is slim. Is very slim, and because these individuals who have taken advantage of individuals, especially individuals who are now in homes, they may even have existing power attorneys. It can happen. We've seen situations where people have lost millions of dollars over a weekend because someone has befriended them in a home without the knowledge of the POAs, the family, the kids, and the kids show up at their bank account on Monday or Tuesday of the following week, and everything's gone. The registered plans are gone. The house has a new, unbelievably high mortgage against it to deal with and not be able to pay for it. And because the person they deemed to say, oh, it was capable enough to sign on this mortgage, you know, they foreclose, they take the property, client's still outstanding, the liabilities on it's like the wheels fall off, and unfortunately, the person who uh, should not have been involved at all is the one who's holding the cards. Yeah, yeah.
yeah. I
Yes.
managed a cemetery. That's brought me to this.
Oh, good. If you do have
I've
cemeteries, yeah, yeah, yeah. I just got involved with, I think in Ontario, 240 cemeteries where we're dealing with all the assets and funds in perpetuity. So we have to manage those funds and keep them going and trying to eke out a little extra income to cover the care costs, for that cemetery. So we, we started moving from just straight the daily savings to a little more diversified with a higher dividends, just to bump up the income and reduce the cost. So power to you if you're doing that. That's good work. Yeah.
So, John, in sort of the conversation between you and Bettina, is that if you had somebody that was under the care, and there was bankruptcy, can you negotiate to get a better rate rather than them being charged like ridiculous amounts, or is that not possible in your
Oh,
capacity?
we're always negotiating. I mean, that's
Okay.
the issue, right? I mean, that's where I remember, yeah. And and sometimes the bankruptcy people are well, I'll find out today how it works, but that's how it works. I know it works clearly when we were dealing with catastrophic injuries, where settlements would come through, and we see the rate that the lawyer is going to charge, and I said, and they would want 30% on the value of whatever they're going on, and the problem is that the size of bankruptcies and the size of catastrophic injuries are so much higher, but they
Hmm.
haven't changed the percentage. Like if you had a Vancouver Toronto property 20 years ago, 30 years ago, it might be a $500,000 property, right? You go bankrupt. Oh, okay, we're going to take a percentage of that. 20%, so there's 100,000. But now the property is 5 million, so we want the 20. We haven't changed the quantity. We still want the 20% or 25. Is that, well, but you haven't added any extra time, right? You can't justify
Yeah.
that. And so the courts, when you go to bankruptcy, well, for us, for cash judges, and that was when would do a cost analysis, this the fees charged for this is far outside what would normally been acquired if in terms of the amount of hours on a
Hmm.
normal fee scale. So cut back on what you're asking for because it still has to be justified, and it's not there for you don't go. It's not there to feather the pockets of the professionals. They have to still it's to cover their costs for doing the work, and at the end of the day, client first has to be essential, i.e., all parties we accept the need once you go to bankruptcy, like that's what we're dealing with here. We're not saying that the client it doesn't owe. What we're trying to do is ensure that we can exempt certain assets, registered assets. We can exempt something net of taxation because in bankruptcy court what's owed by CRA no longer is first and foremost. They can fall into just a standard they get in line with every other every other client, every other applicant who's saying that they're owed money. So yeah, so that's I literally am working through this now. How can we best minimize the amount? And because they're dealing with professionals who are doing the work, a lot of the work, as opposed to the individual, we're are they're preparing a proposal. Well, we're good at doing lots of great proposals as well. So if we can save the time in-house and say, okay, we've done some of our own work, can that effectively save you 30-40% of the time you're going to take? It's like helping a lawyer with settling a sale of a house, things of this nature for probating. It I think anything and everything is negotiable. And if with a public trustee, I think they also see, well, we do the right thing for you. We don't want to get on your bad books because we have 50,000 clients as opposed to a one-off.
Hmm.
And all of a sudden it becomes very clear that, being able to be fair and equitable is important. Yeah.
Hmm.
But Yeah, it's like anything else. You know, we don't, it can't, I think it's a common thing. We don't negotiate enough. We don't haggle enough, and we should, you know, and, and not that people shouldn't get covered for their fees, etc. But, it's always good to say, okay, it's the best you can do under the circumstances. Is there any way we can, what it would take, to reduce what is, but I'm informed under bankruptcy, whatever the fees are being charged by the bankruptcy trustee is carved out of the final package that's accepted by all the by those who are going to be receiving the funds. So it's technically neutral for the client, but the amount that's available for the creditors is diminished, and that I think is something to take into consideration if they're going to feel comfortable accepting that. If they know
Mhm.
that a high percentage of the original gross amount has already been eaten up by the fees. So, you know,
Mhm. Yeah.
I don't.
Sham put
Yeah.
a question in as to
Yes.
how do the OPGT get paid?
Oh, like it's very simple. We have the Trustees Act. We get paid 0.6%. And the annual report,
Mhm.
I've added that. We're very transparent. We're so transparent, it's frightening. We get paid 0.6% of assets under management. So it's not only the investments, but also the real estate. It could even be chattels and things like that. We get 0.6% on that. So if we have, say, $3 billion of assets, we get roughly 0.6% of that. We also get 3% on money coming in, going out. Certain clients who are in Ontario under the Ontario Disability Support Payments, all their compensation that we have is deferred. Okay. It just builds up until finally they turn 65. Once they're off ODSP, if there's assets there, funds there, we can try to recover. At the end of the year, if the cost for managing our clients within that 0.6%, 3% in and out, um, is less than the cost than our fees, then the province will the taxpayer, I guess, will fund the difference, right? But we try to cover our costs in that. And as for financial planners and accountants, we are able to, if on the need to base case by case basis, charge a prescribed fee that's also been approved by the Ontario by the Trustees Act. And it's, you know, it's a standard fare. It's usually a fraction or much lower. And they haven't been changed since I've been here, and that's 20 plus years. So the fees are very reasonable as well. If and that, but many times we try to work within the 0.6% of assets under management and the 3% in and out. And those costs are transparent to the client every single month. They get a statement and they know exactly what their account is. They know exactly how much we were charged for management fees, how much we were charged. And if there's any other costs associated, like we have someone doing investigations and they have to get into a home, or they break into a safety deposit box, you know, their fees are again trusted. And if the person comes into our care and they have a house and the house is vacant, we have to secure that home and deal with that. And we have obviously institutional contracts for our insurance and for maintenance and everything else. And we always try to, which sometimes I get it's a low cost provider. So you say you put a bid in, you have to earn an RFP, registered request for proposal, or there's a new terms now, they have to qualify. The same with our investment managers. They have to put bids in. We're looking for a new Canadian equity manager. They will have to apply. You know, here's, you're going to have $200 million. You know, tell us what you're going to do, what's your benchmark, how much you're going to charge us. And that's why we can get these economies of scale, because we're dealing with the client themselves wouldn't be able to do that individually. It would cost them a lot more. So we're kind of the low cost option that they keep saying. But that's how we compensate, and it's very transparent, and it's going to be yeah. So that's what, when, for example, the client's funds, if they're outside, we would pay a trustee fee of 0.6%, but the funds could be with a financial planner and they're being charged as well. So
Mhm.
we turn out that our team of financial planners, the client's with us, and we can effectively bring the funds in-house, then we can save those external fees, which is good on the client, right? So we bring in, if we're $3 billion in house and we saving 1.5, 2%, and we're getting the same benchmark returns, if not better, you know, than they were doing externally, because we can do it in bulk, then we could be saving $60 million a year for our clients just off from external fees. So we do try, and we are very transparent in that capacity. And if someone or family member or someone who has a right to find out what our costs are, we will do a very clearly defined report on exactly what it is that the client paid and what they've earned. And we have to do that for all our minors, because we have to show money 10,000 came in, you're leaving at age 18. This is what's happened every month, every year. and and so we will not bury them with information, but we give them as much information as needed. And if they don't like that, we'll keep on coming back, because we're not for profit. We're a we're part of the crown, and we're there to disclose what we're able to disclose as much as possible. Right.
So we have two more questions.
Sure.
One
Yeah.
is, there are scenarios where you should be choosing the public trustee as your executor or PO rather than private.
No, no, don't do that. It really doesn't. You technically could do that, but like I say, there's a pecking order. Like
Mhm.
you can say anything you want in your will, the same as you can name anybody you want as a guardian. The courts will decide. But as you say, the Substitute Decisions Act is very clear. There's 8 or 9 distinct institutions or groups that are going to they're going to try to find someone else. And you're absolutely right that a lot of people say, well, I just don't trust anybody. And technically, that may in fact be the case. So, but actually naming the public trustee doesn't securely define that we will be. We'll say no, we can't. We may again. I can't speak, but if there has been negligence, or there has been any type of care, uh, if say the person's in a home, things of this nature, and said, yeah, there is incidents, we may have already started some process to step in to start with. But you don't go and name us in a will or in a power of attorney document. You know, it's
Okay,
not
and
going
the
to you're not going to jump
last,
the queue that way, that type of
right, right.
no, right. Yeah.
That's good to know. And how much work have you done with OCL in Ontario?
Well, that's again, the public trustee tends to work on the assets side as opposed
Mhm.
to the litigation side. So our lawyers will work with the Ontario. In fact, there's a good history of their lawyers for the children as working with us. But our unit, the public trustee, we manage, like you say, about 30,000 accounts for children. And usually it's under the children's lawyer. And if they're receiving assets or funds due to a separation, a divorce, or an inheritance, and the public trust and the money is having to go into trust, we, by the very nature of the OC, we, as the public trustee, do not take on guardianship for children. Other provinces will, right? That's of the OCL. So we separate ourselves. We will manage the actual investments, and then we'll work with accountant of Superior Court of Justice, which is located within our office, who will then interface with the OCL. But the bottom line is that in that capacity, we are more arm's length. We're very arm's length from the day-to-day operations for that. If I don't know if that answers the question, but we're there to manage the funds as opposed to get involved on the litigation or in the care side.
Okay.
Yeah.
Carl's got a question with his hand up, so we'll let him speak.
Yeah, sorry, I should have made that question a little more specific per se to the OCL. So we have a file right now where it is a estate file slash separation file. So they're going through mediation, and then one party committed suicide.
Right.
And now we've got an estate situation. But we also have a family law situation. We've decided that majority of the funds will be paid out in the terms of child support and education costs.
Yes.
My question, of course, is when we're still waiting on the OCL to actually be appointed, which is kind of irritating us. But if the OCL deems that the parent that survived doesn't make good financial decisions, is that when you step in, or what do we do in that kind of case?
That could be the case. Generally, what happens is it is up to the courts to determine if there's not similar to a PGT client. Again, we are just going to be there to be almost like the bank for these assets, these funds. And the funds will come in, but most times the funds when they're brought in are there for a time period. They may not. In this case, you may if would the person then or the say the children be in the position where there's going to be a distribution required on each year, because what happens is that OCL, if they get pulled in, which may in fact be the case, and
Yep.
is deemed that the family member who was going to care for the assets or the funds is deemed should not really, that there is some concern about their capacity to look after the funds. Again, I'm not even going down that path,
Yep.
but if
Yep.
that happens, then yeah, so it absolutely is the case. We have, like we said, we have over $1 billion of money into this, for children under 18 right now, and each client's account, each child's account, and they could be multiple children. We have cases where we have 3 or 4 kids, and we all have to, and each kid could, in fact, based on the age and how, we could have a 15-year-old and so they got 3 years because the situation was that nothing was set up in terms of gift overs and other provisions. So like 18 is the end state for everybody. So in a 4-year-old's got a different time horizon than a 16-year-old. So their portfolios are going to be uniquely different. And that's a key thing.
So, but do you guys then also, like in this case, they have yearly tuition costs because they're all in
Yeah,
private school.
right.
Do you pay those out directly to the parent? Do you directly pay them out to the institution? How do
We
you
could go
manage
right to
those
we
things?
could go right to the institution if
Okay.
it's deemed that it's easier for us to preserve the integrity of the line of transfer of the funds. Because last thing you want to do is hand it out to someone who, first of all, didn't wasn't in the position to take the funds to manage already. It's why are we doing that? So yeah, so that's what happens. That we have our team works directly with there's another office right here. Just say with Marilyn and the other team members, and they say, oh, we have a client that, like, this year client will probably fall under our docket, and they say, okay, they're requiring X dollars to be distributed each year for this person starting this year, next
Okay.
person in 3 years. Here's the amount. Okay, well, we're going to keep those funds in our daily interest buy and hold bond fund. They're going to get 3.6% as of today for that amount of capital, so there's zero
Right.
risk, that type of thing. If anything else is sitting around, we'll be acting as fiduciaries for those funds. But the decision under the ACJ is to follow the actual court order. So the court will determine exactly the distribution and the time. The actual amount obviously is going to be dependent on the institution. Those are going to be flexible. So we're not going to say you're going to pay 5,000 a year and all of a sudden, oh, we can't go anymore because the tuition cost is kind of seven. No, this doesn't. It's not as cut and dry as that. To say to pay this fee at the institution as determined, blah blah blah, and so, but yeah, so we'll act the same way as you would act if you were managing those funds. Okay, well, when do you need to pay out these funds? Are you going to maximize an RESP? That could be the case, right? So if it's an RESP, we don't do RSPs internally, so yeah.
Okay.
Okay. Is there grants and bond, or can we somehow maximize the pool for funds for this thing? Is a group RESP? Are we going to do that? Okay, let's do that. We're going to get extra money from from the province to max that, and the feds. Let's get as much money as we can. We're planners. We want to take advantage of the system as much as possible. Yeah.
We like free money. Yes.
Yes. Yeah.
Okay. Excellent. That's I'm hoping we won't go down that route, but I'm just curious because this was an interesting presentation and just kind of piqued my mind on that one unique file that I have. So thanks.
Yeah, I appreciate that. No, glad
Yeah.
you all came in. Yeah, I know it's a new thing, and I hope I covered some areas that are interesting. And I know I'm jumping in on others timeline, but Linda, I really appreciate you
Yeah.
inviting me to come out.
Oh, well, it was a wonderful presentation. I think we've all learned a lot. I will provide the follow-up docs and things like that for everybody so they can, utilize it. Because, thank you, Carl, for chipping in there, because I think that sometimes we're like, oh, yeah, I'm never going to have this happen. And then you have that other
It's
case.
going to happen. That's right.
Yeah.
Yeah.
So,
And I'm trying to, anyway, well, I don't want to waste anybody else's time, but we're here to help others in the private sector, professionals like yourself, the legal community, everybody, to say, okay, how do you not get us involved? And if you're ever involved, what can we do to expedite what's in the best interest of our client on
yeah.
a timely basis? And if we're able to, you know, extricate ourselves from that scenario, or are there trusted people that we trust? And that's the other thing. We don't send someone else out. We reject applications as much as we approve applications. It's very important. So it's anyway. Thank you, Linda, and
Yeah,
I'm
thank
happy to
you.
have talked to you
Yeah,
all this morning. All right,
great. Thanks very
all right.
much.
Take care.
And
All right,
thanks a lot. Bye.
I take care.
And for everybody now, you have a break until